Welcome back. In this subunit, we're going to discuss the delegation of contractual duties in more detail. All right, in this subunit, we're going to talk some more about the delegation of contractual duties, and we're going to come to a better understanding of the law with respect to the delegation of duties by talking about non-delegable duties and by comparing delegation with another very important concept called novation. All right, before we discuss the details of delegation, let's refresh our memories about what delegation is and how we label each of the parties that is involved with the delegation of a duty. All right, this is our famous fact pattern. We have a homeowner and a house painter, and they have entered into a contract. Under the contract, homeowner promises to pay house painter, and house painter promises to paint homeowner's house. We have C. C is a third party and is not a party to the contract between homeowner and house painter. House painter delegates her contractual duties to C. So a house painter delegates her duty to paint under the contract to C. In this case, house painter is the obligor. Painter is the obligor. Homeowner is the obligee under the contract. Painter is also the delegator because she has delegated her contractual duties to C. And here, C is called the delegate or the delegatee. Let's change it up just a little bit. Our same fact pattern where we have a contract between homeowner and painter, house painter. Homeowner promises to pay painter. Painter promises to paint homeowner's house. C is a third party. C is not a party to the contract between homeowner and painter. Homeowner delegates her duty, her contractual duties to C. What is homeowner's contractual duty? Homeowner's contractual duty is to pay painter. So homeowner delegates that duty to C, which means C will now pay the painter. Under this version of the fact pattern, homeowner is the obligor. Why? Because the delegated duty is homeowner's duty to pay painter. Painter is the obligee. Homeowner is the delegator. She has delegated her duty to pay to C. And C is the delegate or the delegatee. All right, so what type of contractual duties are not delegable? Well, the basic rule is that most contractual duties are indeed delegable. And there are two reasons or two justifications for this. The first is the practical reason. And the practical reason is that when parties enter into a contract and they have obligations, they often need to engage third parties to help them perform their duties. They might have to hire people, hire employees to help them perform, or they might have to subcontract out some work so that they can perform their contractual duties. So we have this practical reason for allowing parties to delegate their duties. The second reason that most contractual duties are delegable is that the obligor who delegates the duties is still liable under the contract. Remember, a delegation of duties is not a transfer of that duty to the delegatee, to the third party. It is just engaging that third party to perform in the obligor's stead. If that third party, if the delegatee breaches the contract or does not perform well under the contract, the obligor is still responsible for that. Well, what does that mean? Well, it means that the obligor still has incentives under the contract to hire good people or to subcontract out to good people and to monitor their performance. Because if I'm an obligor and I delegate my responsibilities under a contract to a delegatee, if that delegatee does not perform well, I am liable under the contract. Now, the rule is that most contractual duties are delegable. Let's talk about the exception to that rule. All right, so what type of contractual duties are not delegable? Well, a contractual duty contracts for personal services. If you're an obligor and you're performing personal services, you may not delegate your duties under the contract to a third party. What are personal services contracts? Well, first let's look at the rule, the test that you might want to use if you're trying to determine whether the obligor is performing personal services under this contract. So if the obligee, if the other party bargained for personal service from the obligor, then the obligor is performing personal services. Or if the obligee has a substantial interest in having the obligor personally perform those services, then it is a contract for personal services. Be careful here. Remember, we're talking about personal services, so we're talking about usually a natural person. It would be strange to say that a corporation, right, with employees and directors and executive officers, that a corporation has entered into a personal services contract. A corporation cannot perform personal services. We're thinking of a natural person. So let's look at a couple examples of what you might be looking for. So if I hire a lawyer, right, a sole practitioner, to perform legal services for me, that lawyer cannot cannot delegate his duties under the contract to another lawyer. Why? Because the lawyer's services are services of a personal nature, right? We have a close relationship. I have chosen this lawyer because of this lawyer's skill and because of how I feel about this lawyer in representing me. So the lawyer is performing personal services. The lawyer cannot delegate that duty to another lawyer. Imagine I enter into a contract for a year's worth of services from a particular doctor, from a particular physician. Can that physician delegate the duty to provide those services to me to another physician? And the answer is arguably no. Why? Because I, the obligee, the patient, I have a substantial interest in having that physician perform. What that physician is doing is performing personal services for me. I have a close personal relationship with my physician, and I don't want that physician to delegate those duties to another physician. All right, so that's one type of category of personal services contract. The other one is where the skill, reputation, ability, wisdom, or taste, artistic, or talent is unique to this person. I like to think of entering into a contract with Elvis. You enter into a contract for Elvis to perform at your concert. Elvis cannot delegate his duties to perform to some other entertainer, even if that entertainer is great, even if that entertainer is similar to Elvis. Elvis is performing personal services and cannot delegate his duties to perform to another entertainer. All right, so we've said that most contractual duties are delegable. The only non-delegable duties are duties of personal services. All right, so let's just take a look at an example that might bring this all together. Let's imagine that I have a duty to make payment under a contract. Is my duty to make payment under a contract delegable? Well, and the answer is yes, unless the contract specifically prohibits it. But my duty to make payment under a contract is indeed delegable. In other words, I can say to a third party, hey, you make payment under this contract for me in my stead. So you might object to this and you might say, well, what if that third party, if that delegatee is not as creditworthy as the contractual party? So I have I have delegated my duty to make payment to this third party. What if that party is not as creditworthy as me? Well, the answer is it doesn't matter. Why? Because I have not transferred my duty to make payment to that third party. I have delegated my duty to make payment to that third party. And if that third party does not make payment to the obligee under the contract, then I am still responsible for it. And that's why a duty to pay is delegable, even to someone who is of high credit risk. If the delegate is someone who has declared bankruptcy and has no money, I can still delegate my duty to pay to that third party. Why? Because I haven't transferred my duty to pay. I am still liable under the contract for that payment. All right, so let's talk about when delegation of a duty would be considered a material breach under a contract. First, let's talk about the situation where the obligor delegates a non-delegable duty. What type of duties are non-delegable? Right, personal services. These are non-delegable. So let's say that I hire Elvis to perform for me, and Elvis delegates the duty to Tom Jones and insists that I accept performance from Tom Jones. Elvis is in material breach of the contract. Good, that's easy enough. Let's move on to the next situation. Let's assume that it's not a personal services contract. We have a situation where the duties under the contract are indeed delegable, but the obligor doesn't say, I am delegating my duties to a third party. The obligor says, I am transferring my duties to a third party. Remember, delegation is not the transfer of a duty. So when the delegator says, when the obligor says, I am transferring my duties to a third party, the obligee has reasonable grounds for insecurity. Are you transferring your obligations? You can't transfer your obligations under a contract. If you are saying, I am transferring my obligations to a third party and I am no longer liable under this contract, then that is anticipatory repudiation. You as an obligor, you can delegate your duties to a third party, but you may not transfer your duties to a third party. So if by saying I am transferring my duties to a third party, you are saying I am no longer liable under this contract, that is anticipatory repudiation. But naturally, because parties are not sure how to use these terms correctly, so when one party says I am transferring my duties, it's probably ambiguous and you probably should ask for reasonable assurances. In other words, the obligee should ask for reasonable assurances when the obligor says, I am transferring my duties. The obligee should say, what do you mean? Do you mean you're transferring your duties so that you are no longer liable under the contract? If the obligor responds, yes, that's what I mean, then the obligor has committed anticipatory repudiation. All right, let's talk about the waiver of non-delegable duties. Can the obligee waive the non-delegability of a contractual duty of the obligor? And the answer is yes. The obligee can either do this expressly or implicitly. Once again, let's take the example of Elvis. I hire Elvis to perform for me. This is a personal services contract, so Elvis's duties under the contract are not delegable. Let's assume that Elvis wants to delegate his duties to Tom Jones, and I'm the obligee, and I say, okay, you may delegate to Tom Jones. I have expressly waived the non-delegability of the obligor's duties. What if, on the other hand, Elvis delegates to Tom Jones without asking my permission, and then I accept performance from Tom Jones and I pay Tom Jones under the contract? Well, then I have not expressly waived the non-delegability of the contractual duty, but I have implicitly waived the non-delegability of the duty. Our last topic in this subunit is the topic of novation. Novation is a fairly easy concept. Let's set it up by comparing it to assignment and delegation. All right, so let's look at this familiar example. We have a contract between A and B. Under the contract, B has certain contractual rights. B also has certain contractual obligations. Party B says, I assign my rights under the contract and I delegate my duties under the contract to Party C. Party C now is the delegate or delegatee, and Party C performs Party B's duties under the contract. But Party B is still a party to the contract. Party B is still responsible. So if Party C doesn't perform the contractual obligations, Party B is liable for breach. That is assignment and delegation. That's what we've talked about up to now. But a novation is different. A novation is a situation where Party C comes in and substitutes for Party B. In other words, Party B is no longer a party to the contract. Party C comes in and takes Party B's place. Under these circumstances, Party B will be relieved of her obligations under the contract. In other words, a novation is different from a delegation. In a delegation, Party B is still liable under the contract. Party B is the original obligor. When she delegates her duties to Party C, she will still be liable for those obligations. But under a novation, Party B is completely relieved of her obligations under the contract. How do we do this? Well, let's go through a few more slides just to discuss how we can do this. Let's look at an example of a novation, a very simple example, and discuss how the parties can accomplish this. It's actually quite simple. So we have a contract between A and B. C is not a contract, is not a party to the contract between A and B. What the parties want is for C to substitute for B. In other words, B drops out of the contract, and in B's place, we put C. So now, the contract that was originally between A and B is now a contract between A and C. And B is now a third party, is not a party to the contract. B has been relieved of all of her obligations under the contract and also has given up all of her rights under the original contract. C now substitutes for B. We could not do this using a delegation. Why? Because when B delegates her contractual duties to C, B is still liable. In the novation case, B is relieved of all of her obligations under the original contract. How can we accomplish this? Well, it's really not that hard. What we need is, we need A, B, and C to all get together and agree that C will now substitute for B. So as long as you have all three parties getting together and agreeing that B will be relieved of her obligations under the contract and will give them up all her rights under the contract, and C will then assume B's obligations under the contract and will be entitled to B's rights under the contract, then you can do a novation. So to accomplish a novation, it's very simple. You just need all three parties to agree that that's what they want to happen. Not very difficult.